And now I'd like to welcome our witnesses to provide testimony on a resolution recommending that the House of Representatives find Mark Meadows in contempt of Congress for refusal to comply with a subpoena duly issued by the Select Committee to investigate the January 6th attack on the United States Capitol. And I do, before I introduce, okay. Let me just make a few comments, and I'm happy to yield again to the ranking member if he has any additional comments. Basically, what we're talking about today is a measure that calls for the House to hold Mark Meadows, the President Trump's former chief of staff, in contempt of Congress for defying a duly issued subpoena, and to refer the matter to the U.S. Attorney. And I don't think anybody here takes that step lightly. Mr. Meadows once agreed to cooperate. He produced documents, but eventually changed course and refused to show up for a deposition. He even refused to answer questions as his book was being released, in which he publicly recounts private conversations he had with President Trump. I think he's fine with doing interviews on Fox News. I guess that's okay, apparently, but he feels that he can't testify before Congress. From the information he turned over to the committee before his stonewalling has made clear he has knowledge and information that is central to this investigation. He's already provided a PowerPoint that, to me, amounts to essentially a paper trail on how to undo the results of an election in the United States. A coup by PowerPoint. It talked about the president declaring a national security emergency and seizing ballots over complete nonsense. President Trump lost the election, period. And a retired U.S. Army colonel who helped circulate the document has come forward and said he visited the White House and spoke to Mr. Meadows 8 or 10 times. I mean, is anyone on the other side shocked by this? Are there people in the Republican conference who are curious about how this thing was drafted or what other information could be out there? I mean, this is stunning. Yet somehow Mr. Meadows thinks he shouldn't have to testify before Congress and answer questions. Give me a break. The texts sent to Mark Meadows that were released by the Select Committee last night were nothing short of a bombshell. The top personalities on Fox News, who are today trying to cover up the gravity of what happened on January 6th, knew who to go to stop the insurrection that day. The president's son knew who to go to. When Don Jr. texted that, quote, "It has gone too far and gotten out of hand," end quote, what was it that he was referring to? The it was the attempt to overthrow the election. The it was the attempted coup in the United States of America. Yet the president did nothing in those critical moments, in what the vice chair has rightly called his supreme dereliction of duty. So based on what we've already seen, I shudder to think what else Mr. Meadows is trying to hide. What we already know, and what is already clear, is that there was an attempted coup that day, aided and abetted from the top down. You know, if you look at world history, the first attempt at a coup doesn't always prevail, but the next time it often does. If we don't get to the bottom of what happened on January 6th, if we don't prevent it from ever happening again, the next time America may not be so lucky. And just let me remind my colleagues of one thing here. This Capitol was attacked. The people who work here were directly threatened. People died. 140 police officers were injured. It took over 3 hours for the people around Donald Trump to get him to respond. Over 3 hours. Let that sink in. Think of all that happened because of his silence. Think of what could have been prevented had he intervened earlier. I mean, I have a tough time trying to figure out what kind of rotten person would stand by while this carnage was happening before his very eyes, while he was watching it on TV. It's sick. But here we are today, and I appreciate the committee's work and determination to get to the truth. And speaking for myself, I will do whatever I think is appropriate and necessary to make sure that you get all the support that you need, because the American people are expecting us to get this right. I don't know if the ranking member has anything to say, but I'm happy to yield to him.
Just quickly, and thank you, Mr. Chairman. Worth noting that, and we'll talk about this, I'm sure, during the testimony. I look forward to that. Mr. Meadows has, submitted literally thousands of pages of documents. And there was, and maybe still is for all I know, and again, I'll look forward to hearing what the chairman and the ranking vice chairman has to say about that. Discussions as to whether it's appropriate. There are legal proceedings here underway as to what the extent of executive privilege here is and what it applies. So I guess that's my big concern is, number one, is this exercise going to get us the information that I know you want and the cooperation, or does it make it less likely? And number two, do we have a legitimate legal question here that we ought to resolve before we proceed with criminal contempt? Doesn't mean the committee shouldn't continue its work, doesn't mean they shouldn't be aggressive in pursuit of the truth, but it does raise some interesting questions and as to whether or not we're going too far, too fast here in this particular action. I think we've seen a couple of occasions of that before. So with that, I'll yield back to you, Mr. Chairman, and look forward to the testimony we're about to hear.
Thank you, and I welcome our witnesses to provide testimony on this resolution. Again, recommending that the House of Representatives find Mark Meadows in contempt of Congress for refusal to comply with the subpoena duly issued by the Select Committee to investigate the January 6th attack on the United States Capitol. Chairman Thompson and Vice Chair Cheney, we're delighted to have you here. I now recognize the gentleman from Mississippi, Mr. Thompson.
Thank you very much, Mr. Chairman, Ranking Member Cole, members of the committee. Thank you for the opportunity to testify today. This is an unfortunate situation we're dealing with today, particularly because it deals with a former colleague, and that situation has been made worse by the amount of dust that's been kicked up to try to distract us from the facts. So let me spell out those facts. The Select Committee sought records and testimony from Mr. Meadows because we believe that he had information relevant to our investigation. He reportedly participated in or witnessed events that are the focus of our work. So on September 23rd, we issued a subpoena for documents and his testimony. After weeks of back and forth with his lawyer, evidenced in the letters we made public with our report, we set a November 12th date for his appearance at a deposition. At that point, he hadn't produced any records, and when the time came, he didn't even show up. We signaled at that time that we were prepared to move forward with contempt proceedings, but we also gave Mr. Meadows a final opportunity to reverse course. We set another deposition for December 8th, and Mr. Meadows initially agreed to provide testimony. Now, throughout this process, Mr. Meadows' attorney has raised claims of executive privilege and so-called absolute immunity. The idea that individuals who hold or held certain positions have no obligation whatsoever to appear before Congress when called. We don't accept those claims. President Biden hasn't asserted executive privilege or absolute immunity regarding Mr. Meadows' testimony. And all the courts that have considered claims of absolute immunity have rejected them. But all that discussion about different privileges is a distraction. That's not what this contempt referral is primarily about. This referral centers on the information that even Mr. Meadows and his attorney says is outside all those claims of privilege. He provided roughly 9,000 pages of records that he and his attorney freely admit cannot be held back by any sort of privilege claim. They gave us a lot of this information. His participation in a January phone call aimed at pressuring state legislators to overturn election results, that's not protected by executive privilege. His communications with Georgia Secretary of State regarding efforts to disrupt election, that's not protected. The list goes on, and while the records he handed over gave us valuable information, they also raised a lot of questions. And then, the day before he was scheduled to appear for his deposition, he changed his mind. He said he was through cooperating with our probe. He refused to come in and answer questions about the non-privileged material. He has no basis to refuse to cooperate on those matters. That alone is sufficient to advance the referral. But for the sake of argument, let's talk about Mr. Meadows' privilege assertions. The Select Committee isn't able to assess whether Mr. Meadows is making those assertions in good faith because he won't even come in and address them on a question-by-question basis as he's required. I have my view of whether he's made these claims in good faith because I've seen him on television talking about his conversations with the president and promoting his book. I understand that this is a difficult matter. I have no great desire to be here seeking consideration of this contempt referral. Mr. Meadows was a colleague for more than 7 years, but that doesn't excuse his behavior. If anything, his time as a member of the House should make him more aware of the potential consequences of defying a congressional subpoena. We've given Mr. Meadows every opportunity to cooperate with our investigation. We've been more than fair. He's brought this situation on himself, but there's no doubt in my mind that he's in contempt of Congress and has to be held accountable. I thank you, Mr. Chairman, for allowing me to open with these comments, and I look forward to your questions and yield back.
Thank you very much. I now recognize Vice Chair Cheney.
Thank you, Mr. Chairman, and thank you, Chairman Thompson, Ranking Member Cole, and all the members of the committee. As the chairman said, it gives us no pleasure to be here again, and to be here dealing with the recommended referral of criminal contempt of a former colleague of ours. We understand it's a serious matter, and it's a step we wouldn't be taking if it weren't necessary. We don't take it lightly, and we hoped we would not have to be here at all. As the chairman noted, we'd engaged in weeks and weeks of discussions with Mr. Meadows' counsel. We'd worked very diligently to try to reach agreement on cooperation. We'd scheduled a deposition at a time and a day of Mr. Meadows' choosing. But shortly before the deposition was to occur, Mr. Meadows walked away from his commitment to appear, and he informed us he would no longer cooperate. As the chairman noted, we think Mr. Meadows is improperly asserting executive and other privileges. But this contempt proceeding relates principally to Mr. Meadows' refusal to testify about the text messages and other communications he admits are not privileged. He has not claimed, and he doesn't have any privilege basis to refuse to answer our questions about these texts and about these topics. I'm just going to talk about 3 areas that are critically important to our investigation, about which Mr. Meadows has turned over materials that are non-privileged and about which he's compelled to answer our questions. As the violence was underway on the 6th, it was evident to all. But we know that for 187 minutes, President Trump refused to act. And he refused to act when his action was required, it was essential, and it was compelled by his duty, compelled by his oath of office. Mr. Meadows received numerous text messages that he has produced without any privilege claim urging President Trump to take action. I read a number of those last night to the nation. Here are a few others from Republican members. Quote, "It is really bad up here on the Hill. Another one, the president needs to stop this ASAP. Another one, fix this now. And as we saw last night, dozens of texts, including from Trump administration officials, from members of the press, from Donald Trump Jr., urged immediate action by the president. But we know hours passed with no action by the president to defend the Congress of the United States from an assault while we were trying to count electoral votes, which was an official proceeding. This brings up another point. Mr. Meadows' testimony will bear on a key question in front of this committee. Did Donald Trump, through action or inaction, corruptly seek to obstruct or impede Congress's official proceeding to count electoral votes? Mr. Meadows' testimony will inform our legislative judgments on those issues. But Mr. Meadows has refused to give any testimony at all, even regarding non-privileged topics. That puts him in contempt of Congress. And let me pause and just note that we as Republicans used to be unified on this point in terms of what happened on January 6th and the responsibility the president had to stop it. We all remember, every one of us, what Republican leader McCarthy said on the floor of the House the following week. Quote, "The president bears responsibility for Wednesday's attack on Congress by mob rioters. He should have immediately denounced the mob when he saw what was unfolding. These facts require immediate action by President Trump." That was Republican leader McCarthy. Mr. Meadows has also got knowledge regarding President Trump's efforts to persuade state officials to alter their official election results. In Georgia, Mr. Meadows participated in a phone call between President Trump and Georgia Secretary of State Raffensperger. He was on the phone when President Trump asked the Secretary of State to, quote, find 11,780 votes to change the result of the election in Georgia. At the time of the call, Mr. Meadows, according to texts he has turned over, appears to have been texting at least one other participant on the call. Again, Mr. Meadows has no conceivable privilege basis to refuse to testify on that topic, and doing so puts him in contempt of Congress. Finally, in the weeks before January 6th, we know that President Trump's appointees at the Justice Department told him repeatedly that his claims of election fraud were not supported by the evidence. They told him the election was not, in fact, stolen. President Trump intended to appoint Jeffrey Clark as Attorney General, in part so that Mr. Clark could alter the Department of Justice's conclusions regarding the election. Mr. Clark has now informed the committee that he anticipates potential criminal prosecution related to these matters, and he intends in upcoming testimony to invoke his Fifth Amendment privilege against self-incrimination. As Mr. Meadows' non-privileged texts reveal, he was communicating multiple times with a member of Congress, a currently serving colleague of ours, who was working with Mr. Clark. Mr. Meadows has no basis to refuse to testify regarding those communications. He is in contempt. January 6th was without precedent. There has been no stronger case in our nation's history for a congressional investigation into the actions of a former president. We must investigate the facts in detail, and we are entitled to ask Mr. Meadows about the non-privileged materials he has produced to us. Any argument that the courts need to resolve privilege issues first is a pretext. We need to question him about emails and texts he has given us without any privilege claim. His role in the Raffensperger call cannot be privileged, nor can his dealings with a member of this body regarding Jeff Clark. We must get to the objective truth and ensure that January 6th never happens again. I urge my colleagues to support this resolution, and I yield back.
Well, thank you very much, and thank you both for your testimony and for the work you're doing. You know, maybe former Chief of Staff Meadows should talk to former Congressman Meadows. When he was serving here, he complained about subpoenas being ignored, information being hidden, and Congress being stonewalled. When it came to other people facing a congressional subpoena, he said, and I quote, "They may be able to ignore Congress, but they won't be able to ignore the American people," end quote. So I don't know what changed when he moved from working for one branch of government to the next. Maybe he's just that afraid of Donald Trump, but there are not two systems of justice in this country. No one is above the law. And, again, the more and more we reflect on what happened on that terrible day, the more and more I am stunned by the stonewalling of people close to Donald Trump. The American people deserve to know what happened and who was responsible. Again, a lot of time went by before the president finally intervened. Lots and lots of, we're seeing some of the texts that were released from Republican lawmakers and others, texting to Mr. Meadows, "We're under siege up here at the Capitol. They've breached the Capitol. Mark, protesters are literally storming the Capitol, breaking windows on doors, rushing in. Is Trump going to say something? There's an armed standoff in the House chamber, at the House chamber door. We are all helpless." Even some Trump administration officials, POTUS has to come out firmly and tell protesters to dissipate. Someone is going to get killed up here. Mark, he needs to stop this now. Tell them to go home. POTUS needs to calm this, I can't repeat it here, down. Even people, and you released this yesterday, in the very conservative news media were begging that there be an intervention, that the president put an end to this. And he didn't. It took hours. I really believe that, they say that sometimes, coups don't succeed the first time, but there could be a second or a third time. What happened that day was so wrong, and the president and some around him behaved in such a way that, quite frankly, everybody's life was endangered here on the Capitol campus. Staff, people who worked in our cafeterias, the Capitol Police, who were injured, and some died. And at some point, enough is enough, and there needs to be a full accounting, and we all need to come together around this. And I get it. The politics is involved in everything we do up here, but this was just so wrong. And if the goal by some is to wait out the clock, to try to invoke stalling tactics so we don't ever get to the finish line, that's a terrible tragedy for this country. And we were there. Many of us were there on the floor that day. I was in the chair that day. And when I walked out into the speaker's gallery, I came face to face with this angry mob smashing the doors to get into the speaker's lobby. I couldn't believe what was happening here. I never thought such a thing would ever happen up here. And for people to try to minimize that, or to try to invoke delaying tactics, or to try to characterize it as something that it was not. This was not a group of people interested in protecting our democracy. This was a group of people trying to destroy our democracy. So I regret that we have to be here and invoke the measures that we're about to do, but this is serious business, and I commend you both for your efforts here. And but again, I think that we need a full accounting of what happened, and we need to understand why the president waited so long. Hours, hours went by before he finally decided to say anything. So I thank you. I have no questions. Mr. Cole.
Thank you, Mr. Chairman. Mr. Chairman, I wanted to introduce a letter that was sent to the council by the council from Mr. Meadows to Mr. Thompson, Chairman Thompson, and the other members of the Select Committee on December 13th, and just to ask unanimous consent
Without
to enter
objection.
it into the record. Thank you very much. Mr. Chairman, did Mr. Meadows write you on October the 6th to request the Select Committee identify topics which he might be able to provide useful, non-privileged information?
I'm certain he did, if you're referring to a letter.
Yeah, I'm sure you're right. Did you engage in accommodations process to narrow the scope of the subpoena? Was that a serious back and forth discussion?
Well, we've been back and forth with Mr. Meadows' counsel since September on various issues. At no point did we refuse to engage him.
Did you ever seriously consider, was your subpoena absolute, or were you willing to say, yeah, there are some privileged areas here that perhaps are beyond what we should be
Well,
inquiring?
the subpoena spoke for itself, Mr. Ranking Member. What we tried to do was to accommodate his counsel on any questions to the extent practicable. That was what we did.
Okay. On November 3rd, didn't Mr. Meadows write again, stating he was, quote, willing to explore with the Select Committee whether outside the confines of the subpoena an accommodation could be reached by which he might be able to answer under agreed-upon appropriate circumstances a limited set of questions that would further a valid legislative purpose within the scope of the Select Committee?
Well, the subpoena required a deposition, and we have, as a committee, sought to depose him pursuant to that. Now, we can negotiate around some other issues, but he has to sit for the deposition.
And can that deposition be limited in any way before you sit down? Isn't that the purpose of the negotiation, to see, okay, there's non-privileged matters that certainly, and as you suggested in your testimony, and he clearly thought there were areas that were non-privileged that were appropriate for the committee to be asking about.
Well, if he felt there were areas that would be outside, then he could put them forth at that proper time, but we felt that he needed to do it at the deposition.
Okay. After additional exchanges of letters, you wrote to Mr. Meadows on November 9th, unilaterally stating that, quote, it appears the accommodation process has reached its natural conclusion, yet Mr. Meadows was still seeking to define the contours of accommodation. Is that correct?
That's correct.
Okay. What legal standard did you use as the basis for your decision to decide, despite ongoing correspondence, that the accommodations process was over?
Well, the legal standard was the fact that every person that has offered testimony to the committee, we've tried to work with them. But it's the committee's standards that we adhere to, not the other individual.
Okay, on November 19th, did Mr. Meadows send you a letter to clearly communicating a list of topics on which he was willing to provide responses to written interrogations?
Well, in all deference to Mr. Meadows' counsel, then, he can say it, but it's left up to us to accept it as a committee.
Mr. Chairman, could I'd like to make sure that we enter into the record all of the chairman's responses to Mr. Meadows' attorney, because in addition to what the ranking member is referring to, the committee has engaged with Mr. Meadows' counsel multiple times, providing with him lists of topics about which we'd like to question him that are clearly non-privileged. And if he has a privilege claim he needs to make, he needs to appear and assert it on the record. But his refusal to appear at the deposition that was scheduled when he requested it be scheduled at the end of multiple exchanges back and forth made his assertion of that privilege on the record impossible. And he has never indicated to us any justification for his refusal to appear to discuss non-privileged materials, and that's because he has no basis for which to refuse to appear to discuss those materials.
Without objection.
Okay, Mr. Chairman, has Mr. Meadows provided you with 1,139 documents, 6,836 total pages, and a privilege log for any documents withheld?
He has provided the committee with a number of documents.
Okay, did Mr. Meadows also provide 2,319 text messages and a metadata from his personal cell, and 20 documents from his personal computer, and a privilege log for any withheld text messages?
Well, to the extent that the numbers you quote are correct, those documents are what we have. The question, Mr. Ranking Member, for a lot of us is, now that we're in receipt of those documents, we wanted to talk to Mr. Meadows about them, and that's why we wanted to get him before the committee for deposition, and he's refused to come.
On the subpoena in question, did the committee issue it for law enforcement purposes or legislative purposes or both?
I would say for legislative purposes.
Okay, that's what I assumed. During our hearing on the Jeffrey Clark criminal contempt resolution, you and your colleagues repeatedly said that Clark could not raise executive privilege pursuant to Trump versus Thompson because Clark was not the one in court, but Mr. Meadows is in court. Is that correct?
That's correct.
Okay. And well, again, during the same hearing, you and your colleagues repeatedly referred to the need for document production in order to continue your investigation. If that's, and I'm sure that is the case, but then why are we advancing a measure here that's purely punitive? That is, the committee's not pursuing civil enforcement of the subpoena. Why not the civil course? Why the criminal course?
Well, clearly the criminal choice is what the committee made. We see the lawsuit merely as a delaying tactic on the part of Mr. Meadows, and we have given him, as I've said earlier, every opportunity to come to the committee. We negotiated with him, and at the last moment, he said he's not coming, and then he filed suit, which is his choice. We don't have to, as a committee,
Yeah,
to
no,
honor the suit.
again, I'm just trying to be clear on this because you clearly had a choice to make, and I think when you choose the criminal course, you assure you're not going to get cooperation. When you choose the civil choice, you might. So I'm just trying to understand why not try that first, civil contempt, as opposed to criminal contempt.
It was a decision that the committee made to go the criminal route.
Okay. Thank you very much, Mr. Chairman. Thank you, Mr. Chairman. I yield back.
Thank you. Mr. Torres. Dr. Burgess.
So, Mr. Thompson, just to your last statement, that there was a choice that the committee made to go the criminal route and not the civil route. Did you have a hearing? Did you take a vote on that?
Well, we take a vote on everything we do as a committee. The committee looked at it, the choices. Obviously, we could do a number of things. We could do nothing. But we felt in the interest of getting as much information as we could, we pursued the criminal route. It's the more expeditious route. The civil would probably end us up in the years of litigation, which would delay the work of the committee.
So is your ultimate goal for a criminal referral to a branch of law enforcement because you don't have the force of the Department of Justice?
No, once we pursue the criminal, it's out of our hand. It's Department of Justice effort after that. We've done it one other time and successfully. But if Steve Bannon decides to defend himself in court, that's independent of our committee. Our goal is to try to get to the facts and circumstances that brought about January 6th.
Okay, to that point, let me just ask you, are there other documents that you're pursuing to get to that end, to achieve that end? Are you looking at correspondence and emails from the mayor of Washington DC to the decision to not have protection here on the Capitol?
Yeah, well, the mayor is scheduled to testify before our committee. So, I mean, if you know of someone that we ought to bring before the committee to testify, our process has been open. We get suggestions from a number of people.
Well, I will give you these two suggestions. The Speaker of the House and the Senate Majority Leader, Mr. McConnell, had the obligation of protecting the Capitol that day. As a member of Congress, I'm extremely interested in what data they sought, what if there are discoverable items in emails or texts or other documents. I expect your committee to pursue it with just the amount of vigor they're pursuing what many of us see as a purely political process. If you really want to get to the answers, if you really want to protect the Capitol against any future attempts, as Mr. McGovern keeps alluding to, why would you not go to the source, the two people who are tasked with the protection of this institution?
I'll yield to the vice chair.
Thank you very much.
Well, wait.
The committee
The question is to the chairman.
Well,
You're in charge of this investigation.
I'd like to add something, Mr. Burgess. I'm sure you won't mind if I do, in the interest of transparency and getting to the facts. Our investigation, as the chairman has noted multiple times, is very broad, gets at exactly the issues you've described. I'd be happy also to forward you the Senate report that has already been completed on those issues, on which we are adding. The issues around the security at the Capitol is critically important. I take issue, though, you describe go to the source. I don't believe that it is your view. I'd be stunned, frankly, if it is, and certainly the facts and the evidence do not bear out the notion that the source of the attack on January 6th was somebody here in the Capitol. This investigation has got to include what happened with respect to intelligence, what happened with respect to law enforcement, what happened here at the Capitol. But there is no doubt that the summoning of the mob to Washington, the provocation of the attack on the Capitol, and the 187 minutes during which we were under violent attack and President of the United States refused to act are indeed critically important areas where, for legislative purposes, which have been affirmed by both the Federal District Court for the District of Columbia and the Circuit Court for the District of Columbia, we have valid legislative purposes to get this information. And I think that with all due respect, my colleague fully understands that.
You know, I don't think that's an accurate assessment. I was aware of people talking just amongst themselves here in the Capitol, the day of the swearing in, the day after the swearing in. Are you worried about what's going to happen later in the week? Do you know about the people that that the Proud Boys are going to be here? I did not know. Can't say that I actually knew who the Proud Boys were. But these were topics of general discussion going on here. So if you know that, and look, we've had bad protests here at the Capitol before. I was here when the Affordable Care Act went through the legislative process. You don't think we had some really upset people outside the Capitol during those days? Of course we did. It's what we do here. But where was the preparation for what everyone seemed to know was coming? Why did it stop? And that is the question that I hope
Will the
you are
gentleman
serious-
yield? Will the gentleman
No,
yield?
I will not. This is important. This is the question that I hope you, as an investigative committee, if you were to do your work, Mr. McGovern keeps talking about the next one, the next one, the next one. Let's protect ourselves against the next one by understanding where the deficit were prior to this one. And, Mr. Chairman, I just ask a copy of the letter from the mayor of Washington, D.C. to the acting U.S. Attorney General and the acting Secretary of Defense be made part of the record.
Without objection.
And I'll yield back.
I think, did you want to respond? Yeah, I think-
Well, let me just say that I don't know how you can draw a comparison between the Affordable Care demonstration and what occurred on January 6th.
Right.
I mean, people broke into this institution. They harmed people. They did all kinds of things. Look at any video, Mr. Burgess, that you want to see. This is not the America that we live in. I am thoroughly concerned that for some reason, people did that. And with House Resolution 503, we are tasked with the responsibility of looking to the facts and circumstances of what happened. So I say, if you have additional witnesses you want to suggest, get it to us. But we'll do our work. We'll produce a defensible product based on the facts and circumstances behind what we come up with. And it's not going to be easy, because just like Mr. Meadows started off engaging the committee and stopped in midstream. I don't know if it was the former president saying what he was saying and what he put in his book was fake news, but he stopped right in the middle of an effort that our committee legitimately started negotiating with him. And after a former President Trump made the statement, fake news, we never got another word from Mr. Meadows.
Mr. Perlmutter.
Article 3, let's see, Article 2, Section 1. This is the President's oath. I do solemnly swear that I will faithfully execute the office of President of the United States and will, to the best of my ability, preserve, protect, and defend the Constitution of the United States. Then Article 6, Clause 3, for all of us, we shall be bound by oath or affirmation to support the Constitution. We all take an oath. I do solemnly swear that I will support and defend the Constitution of the United States against all enemies, foreign and domestic, that I will bear true faith and allegiance to the same, that I take this obligation freely without mental reservation or purpose of evasion, and that I will well and faithfully discharge the duties of the office on which I am about to enter. So help me God. You know, I'm surprised, because I think what we're going to get next from Mr. Meadows is probably something like we got from Mr. Clark about the desire to take the Fifth Amendment. Because 18 U.S.C. 115, following, Article 3, Clause 1, treason against the United States shall consist only in levying war against them or in adhering to the enemies, giving them aid and comfort. Treason is defined, going back to dictionary. Treason is the crime of attacking a state authority to which one owes allegiance. And what you've described is the minute Donald Trump said fake news, all of a sudden everything stops because there's a pledge of allegiance to Donald Trump above and beyond the Constitution here, which really is frightening. And 18 U.S.C. 115, which is why I think that we're going to see the Fifth Amendment being pled, whoever, owing allegiance to the United States, levies war against them or adheres to their enemies, giving them aid and comfort within the United States or elsewhere, is guilty of treason and shall suffer death. I mean, this is a death penalty statute. Or shall be imprisoned not less than 5 years and fined under this title but not less than $10,000, and shall be incapable of holding any office under the United States. And just the memos that have been disclosed to this point, in my opinion, are treasonous. And we've danced around this a lot, and we talk about obstructing Congress and things like that, but this was an effort to have a coup, to overthrow the country, to break the pledge of allegiance we make to this country and to the Constitution. I really am disappointed in Mr. Meadows. We always had a good working relationship here. He has two masters, Donald Trump and the United States of America, and I could see he's in a pickle about that, but it's the United States of America and the Constitution of the United States to which he owes allegiance, and I hope that he will fulfill his oath that he took as a member of Congress and the oath that he takes as an officer of the federal government to uphold the Constitution. With that, I yield back.
Thank you. Ms. Fishbach.
I'm just going to associate myself with the comments of the ranking member, and I will have questions for Mr. Armstrong when he arrives.
Okay, thank you.
Thank you.
Mr. Raskin.
Thank you, Mr. Chairman. After producing 9,000 pages of documents and saying he would comply with the committee's subpoena, after agreeing to come and testify, and after extensive cooperation with the committee, Mr. Meadows' book, The Chief's Chief, came out, and President Trump exploded and called it fake news. And Mr. Meadows amazingly echoed that and agreed that it was fake news, and then he said he would no longer participate. He would not come and testify, to the astonishment of everyone on the committee, after saying he would come forward. Then he goes to court as a delaying game, as you say, Mr. Chairman, to try to throw a monkey wrench into the process he'd been cooperating with up until Donald Trump blew his top. His central argument there is that we have no legitimate legislative purpose in conducting this investigation. Okay, so that's the heart of the matter. I want to read to you guys Article 1, Section 8, Clause 15 of the Constitution under the powers of Congress. Congress has the power to provide for calling forth the militia to execute the laws of the Union, to suppress insurrections, and to repel invasions. Mr. Chairman, what do you make of the claim that the Congress of the United States, the House of Representatives, does not have the power to investigate a violent mob attack on the Capitol of the United States? What happened, how it got started, who paid for it? What do you make of that claim?
Well, I think it's just patently wrong. Clearly, H.R. 503 gives us the authority as a committee to look at all the facts and circumstances surrounding January 6th. And that's what we're doing.
Oh, it's very clear that House Resolution 503 commands us to do precisely what the committee is doing, but he's suggesting that it's somehow unconstitutional, that the Congress doesn't have the authority to investigate an attack on the government of the United States, an attempt to overthrow the election. Madam Vice Chair, what do you think about that claim?
Well, I think it's wrong, and I think the federal courts have also made very clear, just in the last 2 weeks or 3 weeks, that in fact the committee has stated a completely appropriate legislative purpose. So it's not an issue anymore.
Judge Chutkin, in looking at former President Trump's arguments, said presidents are not kings, and the plaintiff isn't president. Mr. Chairman, this really goes to the heart of our system, doesn't it? Do we have kings here? Do we have lords and nobles and friends of presidents who don't have to respond to congressional subpoenas or court subpoenas if they don't want to?
It is not up to individuals. We're a nation of laws, and clearly, because we're a nation of laws, people have to respect those laws and follow them.
Ms. Cheney, do we have to remind some of our friends what the American Revolution was about and what our Constitution says? Does our Constitution allow for kings, nobles, lords, people who are above the law?
Certainly, it does not. No one's above the law. We are a nation of laws. And I'm just so struck, frankly, by something my colleague from Texas said a few moments ago in talking about the attack on January 6th, when he said, quote, "It's what we do here." No, it isn't what we do here. That's not what we do here. We can have debates and discussions about the law, about policy, about what is an appropriate role, but January 6th is not what we do here, and it can never be what we do here. And we have an obligation and we have a duty to ensure that the functioning of the government, the official proceedings of Congress, and it's difficult to imagine a more important official proceeding of Congress than counting electoral votes, that those who might attempt through either action or inaction to obstruct or delay those proceedings, that we get to the facts, that we understand what our legislative role is in protecting this nation, protecting the Constitution, protecting this Congress from making sure that ever happens again.
Well,
Mr.
gentlemen, Mr. Raskin, I'm from a part of this country where Congress had to pass laws so that people of color could vote. Because in my area, even Benny Thompson getting elected, it took a Voting Rights Act for that to occur. I'm a third-generation person in this same little community I represent, but there has to be a place for our federal government when all else fails. And what you saw on January 6th was an absolute failure on the part of a lot of systems. And those systems are under review right now. So bringing witnesses to our committee, seeking testimony from individuals who have information, we are absolutely open to that process. We are not trying to tailor it in a particular direction. We want to get to the facts and circumstances. There's no ifs, ands, and buts about it. But the buck stops with our committee to come with an objective report based on the facts. And
Hey, haven't you overseen something like 300 witnesses coming in either voluntarily or under subpoena, complying with the requests of the committee? The vast majority of the people have participated, right?
Only 3 people at this point of the over 300 has not.
Ms. Cheney, the claim that a former president is not subject to legal process is extremely far-fetched, given the Supreme Court has found that the sitting president is subject to legal process. Do you remember a 1997 decision in a case called Clinton versus Jones? Remember the Paula Jones case?
I do.
And you remember the Supreme Court saying that the President of the United States, who's in office right now, is subject to civil suit? Is there any reason to believe that a former president is not subject to legal process, or even worse, that he can wave a magic wand and keep other people from having to testify?
No, and I think that last point is really critical. There are issues that we are litigating here, there's no question. But people need to remember that the current president, as to many of the matters we are discussing, has waived executive privilege. Mr. Meadows has, in fact, received indication that from the sitting president, from the White House, that he needs to appear, he needs to testify. And we are, as we have said repeatedly, focusing on matters over which he has no ability, no possible claim of privilege. If he would like to assert privilege, he needs to appear and do so. A blanket notion that somehow I've determined I'm not going to appear because of privilege is not proper.
It has no basis in the law, right? Now, as you say, the executive privilege belongs to the President of the United States. Has President Biden come in to invoke executive privilege to stop Mark Meadows from testifying about what took place on January 6th?
No.
He is not, right? And has former President Trump, Mr. Chairman, although he has no say in the matter, but has he even tried to come into the committee to block the committee from taking Meadows' testimony? No. Well, does the Constitution, Ms. Cheney, have an office of former president?
No. Now, it is the case that there are some instances where a former president may assert privilege. But in those cases where the current president has made the determination that he will not be asserting privilege, and there is a process that the committee is undergoing, then the former president does not have the power to stop the Congress from investigating an attack on Congress and to prevent people from testifying who have information about that attack simply because, of some notion that he can.
What if it would be embarrassing to him?
Right. Those are not privileges that exist in the common law. There's no basis for that.
Well, you say that a former president can try to raise a claim of privilege, which is exactly what Donald Trump did in Trump versus Benny Thompson. And now we have definitive rulings by the Federal District Court and by the D.C. Circuit Court of Appeals panel headed by Judge Millett on precisely that point. And Madam Vice Chair, I'm afraid you stated a little bit too categorically. I don't want people to think that a former president can just assert executive privilege and it works. He can raise the executive privilege as he just did, and he got slapped down so far at every level in the federal courts. And what's the analysis the court goes through? Well, it starts with the presumption, as you do, that under the American rule of law, everybody owes his or her complete truthful testimony to the Congress of the United States if it comes calling with a subpoena, just like in a court. That's the presumption, and the people have the right to know because this is a democracy. Now, what could be countervailing to that is some compelling interest provided by a president sitting, or an extremely compelling interest provided by a former president. And the D.C. Circuit Court of Appeals, with Judge Millett deciding, unanimously said not only was there no compelling or extremely compelling reason to overthrow the presumption that Meadows had to testify, Donald Trump did not even offer one. He could not even offer an interest. Well, what about the interest in doing this again someday? Is that a compelling interest that a president could incite a violent insurrection against the Union? Do we want to shield any information about that in order to protect a president from doing that in the future, Mr. Thompson?
I would hope not.
Ms. Cheney, what do you think about that?
No, of course not. And I think that the point that you're making is very important for people to understand. We all talk about executive privilege broadly. It's a qualified privilege. And when there is an interest, as there is clearly here, that is a privilege that does not shield entirely from someone's duty to testify. I would also say that we're at the point now where there are many of these details of what happened that we have heard so many times that I think it's really important for people to pause for a moment and recognize what we're talking about. When we say we need to ask Mr. Meadows questions about the President of the United States' effort to make Jeffrey Clark Attorney General, Mr. Meadows' questions about his discussions with members of Congress about that, and about what was at the heart of that determination, the effort to overturn the election results in Georgia and in other states. I mean, those are the kinds of things, if you had said a year and a half ago, I think people would have been stunned. But we have to be very sure that we don't become so accustomed to hearing the really grave details of what this president was doing that we move on from the importance of understanding the specifics and the minute-by-minute of what happened.
Well, and let me close with a couple questions about that, Madam Vice Chair. Last night, the committee invoked a whole set of messages that were discovered in asking questions to Mr. Meadows, including Republican lawmakers and others sending frantic messages saying, "We are under siege up here at the Capitol. They have breached the Capitol. Mark, protesters are literally storming the Capitol, breaking windows on our doors, rushing in." Is Trump going to say something? There's an armed standoff at the House chamber door. We are all helpless. Here's some more. This one came from Laura Ingraham. It was identified. Mark, the president needs to tell people in the Capitol to go home. This is hurting all of us. He is destroying his legacy. Brian Kilmeade, please get him on TV, destroying everything you have accomplished. Sean Hannity, can he make a statement, ask people to leave the Capitol? Donald Trump Jr., he's got to condemn this excrement ASAP. The Capitol Police tweet is not enough. Meadows responding, I'm pushing it hard, I agree. Donald Trump Jr., we need an Oval Office address. He has to lead now. It has gone too far and gotten out of hand. Now, Madam Vice Chair, why is it not sufficient just to say, well, he complied up until the point when Donald Trump essentially told him to stop complying? Why is his testimony further needed by our committee?
Because there are well, first of all, it's compelled by the subpoena. He's required by our subpoena to both produce documents and to answer questions, to appear to testify. And there are a multitude of questions that we need to ask him. We need to ask him, we need to understand what was going on, what were his discussions with the member of this body about making Jeffrey Clark Attorney General. Why did they want to make Jeffrey Clark Attorney General? What did he think about the letter that Jeffrey Clark was proposing to send to state legislators in Georgia to overturn the results of those elections? Why were Fox News hosts texting him, telling him that they needed to get the president out to stop this? Why did they think that the president was the one who could stop this? Because many of those same people now are in fact saying, gosh, this was just tourists. Or this was a false flag operation, another person on Fox News has claimed. So I think there are real questions about what those discussions were. I think there are questions we need to ask about what their plans were, what plans they were making on January 6th, what plans they were making with respect to the vice president, what plans they were making to have the vice president to get outside legal counsel to tell the vice president that he could in fact decide not to count certain electoral votes. The American people deserve to know all of the steps that Donald Trump, that those around him, that his campaign were taking in an effort to change the results, to overturn the election, to delay the electoral count. And again, the messages that Mr. Meadows has turned over are non-privileged, and he has a duty under
Everyone agrees
subpoena.
to that. No one
Right.
claims. So the executive privilege argument, as the chairman said, is pretty much a distraction at this point, because
It's-
we're
it's a
talking about
pretext.
questioning him about things that he's already
And
produced.
he has
Yeah.
a duty under the subpoena. He also has a duty as an American citizen, and he has a duty as somebody who served in a position of public trust, who swore an oath under God to our Constitution. He's got a duty to come forth and tell us what he knows.
Thank you.
Well, and the vice chair is absolutely correct. The other thing, Mr. Raskin, is this information was provided by Mr. Meadows to the committee. And what we gleaned from that information was enough that we needed to have him in person to come and explain the information that he had provided to the committee, of which he's denied to come.
Well, let me ask you about it, and I'll close with this question, Mr. Chairman. You know, there's so much cynicism now in the public. Some people would invite us to believe that everything that happens in our politics is just lies, disinformation, fake news. What's the importance of the committee actually trying to establish the facts of what took place?
Well, I think absolutely. That's the core objective of the committee, is to get to the facts and circumstances that we can prove. Now, I think part of what you just read, why would all these people text the President of the United States and say, you have to stop these people? There's some connection between those individuals doing the text and who they're doing it to. And our committee needs to figure out in our investigation what those connections are. And the only way we can prove and get to those connections is have the people who are communicating with that to come before the committee.
You mean they weren't texting you to call it off?
No, sir.
Were they texting you, Ms. Cheney, to call it off?
They were not.
Seemed just to go to Mr. Meadows and the president. I yield back to you, Mr. Chairman.
Ms. Scanlon.
Thank you, Mr. Chairman, and I do want to express our continued appreciation to the members of the January 6th committee for your tenacity, your steadfast patriotism and courage, and your focus on the actual issues before the committee, which would be, why was there an attack on this building, a physical attack on this building, a physical attack on the Constitution on January 6th, and how can we prevent such attacks in the future? And your focus, despite the intense pressure to block your inquiries and attempts to distract, to denigrate the severity of what happened, to deflect, to throw dust in our eyes, I think is what the chairman said. Chairman McGovern referenced the mental gymnastics required to support Mr. Meadows' claim that he doesn't have to testify in response to a congressional subpoena. He's claiming he doesn't have to testify because of executive privilege, that everything he knows was privileged in some manner, and that's simply not true, I think, as you've laid out quite compellingly. It's a distraction because there's no executive privilege from talking about conversations with people who aren't part of the government. There's no executive privilege for conversations about political as opposed to official activity. There's no executive privilege for crimes against the country. So all of this is just a distraction. But also, Mr. Meadows has already admitted that much of what he knows is not privileged. He's turned over these thousands of pages of documents. He's said that privilege protects his conversations with the former president at the same time as he has embarked upon a tour to sell books about his conversations with the former president. And it's so disappointing, so profoundly disappointing that our colleagues across the aisle are engaging in the same mental gymnastics to assist this stonewalling, to assist this cover-up. Last week, we were told that it was premature to start contempt proceedings against Mr. Clark because he had not yet filed a suit to quash the subpoena against him. Today, it's been suggested that it's too late to start contempt proceedings against Mr. Meadows because he has already filed a lawsuit to try to quash his subpoena. As the vice chair suggested, they're flipping the burden of proof with respect to who has to claim privilege here. They're suggesting that the January 6th committee has to guess what elements of unprivileged communication Mr. Meadows has when it's actually his duty to carve out the areas that he can't testify about. So it's all completely through the looking glass at this time. And again, thank you for your patience and for forging ahead on all of this. I think it's increasingly clear that the real and very present danger before this Congress and the country is the ongoing threat to our Constitution and the rule of law posed by the lack of a common understanding, which this committee is tasked with getting, about what happened on January 6th, and accountability, which thus far has been lacking for why that happened. It appears that Mr. Meadows is more afraid of the former president than he is of defying a legitimate subpoena. And that's simply unacceptable. And the fact that some of our colleagues appear similarly frightened of the former president as opposed to standing up for the Constitution is also frightening. The fact that any member of Congress is willing to excuse or support a fiction that this was not a serious assault on our Constitution or that there is any legitimate reason to defy these subpoenas is a fair measure of the threat to our democracy at this point. So again, I commend your efforts. I look forward to supporting this rule and the resolution, and I would yield back. Thank you.
Thank you. Mr. Morelli.
Thank you, Mr. Chairman. And I want to continue to add my thanks to both of you and to the members of the committee for the extraordinary work that you are doing. You know, I'm a bit of a fan of old movies, and I think back to one of my favorite films is Gaslight, the 1944 version. Charles Boyer, tries to convince his wife, played by Ingrid Bergman, that she's insane. He dims the gas lights to make her think she's hallucinating. And that film gave rise to the term gaslighting, the act of making someone question their own reality. And I can't help but think that American citizens are victims of gaslighting, that we are literally questioning, many Americans are questioning the reality of what they witnessed with their own eyes in real time on January 6th. And I know that members have described the attack on the building, the attack on us as members of Congress, but although those are obviously very important, it was more an attack literally on the Constitution of the United States and the Republic that helps define it. And not only are we asking Americans, some of us asking Americans to ignore what they saw, but as my colleagues have pointed out, the contemporary accounts of people who experienced the events, who wrote text messages, who in the days following condemned what had happened, and yet today seem to have had this amnesia about what had happened, or now frame it in ways that are completely divergent from what they did in their accounts in the days and the hours and days that followed the attack. And I agree also with my colleagues. I think these are the darkest days America has faced, and that our republic is in grave danger, and the work that you're doing will hopefully, I pray, help save this republic. I also want to say, this is completely a digression, and this is Joe Morelli's opinion. I don't know that anybody's written about it. I find it highly inappropriate that a White House chief of staff would publish a tell-all book within 10 months of leaving office, just as a complete aside. I find that so indecent and without honor that it makes me question so many things about what we do. And I would hope there's no precedent for that in the future. But it is, however, insightful in many ways and what was going on at the time. So maybe while I find it indecent that you would do it for financial gain, it does give us a window on what happened. And I also find it mystifying that Mr. Meadows would tell all in a way to gain financially for himself, but isn't prepared to testify in front of Congress in order to save the country and the republic. But I wanted to go back, and I certainly don't in any way want to suggest that my good friend from Oklahoma meant this, but the notion of sort of bringing up the number of texts and documents that Mr. Meadows submitted to the committee does not obviate the need, and I think the vice chair said this, to come and testify. It's not as though in a criminal proceeding or a subpoena by Congress that people can individually just choose, well, I'll submit documents, and I'm not suggesting that the gentleman was suggesting this, but it would lead someone to question, is it necessary then for me to testify when I'm called? I mean, will just the submission of documents suffice? Is that, and I do think the vice chair answered this, so you can certainly feel free to comment further, but there's clearly questions that arise when you get the documents. You want, and I assume this is the whole point of asking someone to testify in any place where a subpoena is appropriate, to answer questions about the documents submitted. Is that not what the whole point of this is?
Well, I mean, absolutely, and for us to take those documents and develop the next line of questioning in person of that individual, of which Mr. Meadows failed to follow through.
And I assume, I haven't seen the documents in question, the texts and the emails and other documents, but I assume they have given rise to probably hundreds of additional questions where the members of the committee and the Congress and the American public should have the right to have the questions about those documents answered. And I don't know, Madam Vice Chair, if you want to comment on that.
Yes, absolutely, you're right, Mr. Morelli. And you also mentioned Mr. Meadows' book. As the committee described last night, there are many instances in Mr. Meadows' book where he talks about issues that are of great interest to us, including, for example, he recounts a conversation that he had with former President Trump right after the former president urged people to march to the Capitol, and told people he would be with them in that march. And Mr. Meadows recounts his conversation after that. So, of course, details like that he is recounting in a book, but then refusing to answer questions before Congress about, there are legitimate questions that he is obligated to appear to provide responses, and failing to do so puts him in contempt.
And I do find, I continue to scratch my head about the notion you would author a book on the subject, sell it to the American public, and not be willing to testify to Congress about the comments you made in the book. It's really astonishing to me that we're here. And I also, my colleagues have raised this, it's almost as though, and I appreciate what people have said, and I don't want to engage in repeating this, but it's almost as though if you engage in treasonous activities in plain sight, and with many of your colleagues gathered around you to engage in that treasonous activity, it's almost as though you think that that's okay, that somehow doing it in plain sight somehow allows that to be an okay thing. And I suppose that the precedent that my colleagues have mentioned, that if a future president decides that he is going to be, or she is going to be protected by just invoking privilege, but engages in a pretty wide conspiracy against the United States government and by extension the people of the United States, that would somehow be okay. I mean, I guess you would avoid all accountability if you follow this to its logical conclusion, which I find honestly astonishing. And I'll repeat again, I think these are the darkest days, and I think that it bears repeating by all of us over and over again to our constituents and to the American public that this may be difficult. This may be, in some ways, just ugly to hear about, to see, to investigate, but it is vital. It goes to the foundation and the core of what we believe as Americans. So I want to, again, thank you for your work, your service to the country. I can think of nothing more important facing the Congress right now. With that, I'll yield back, Mr. Chair.
Thank you. Ms. Ross.
Thank you, Mr. Chairman, and I want to just thank the chair and the vice chair again. And I want to point something out about this commission that dawned on me because of something I read over the weekend. You know, the American public is paying attention to what we're doing here in the Rules Committee and on the floor because we now have 3 people who, let's just be honest, were at the heart of this conspiracy, who are refusing to allow Congress to hold them accountable for their actions. But there are so many people who have testified before this commission, provided honest testimony, despite whatever political or financial or occupational backlash they might have. And I know it's not in our jurisdiction, but I'd love to have a list of those brave men and women who have put their country first, as your commission has. And so I want to thank you for that. It is unfortunate that we're having to be here now for the 3rd time to consider lawless actions on behalf of people at the heart of this matter who will not put country first and who are not taking the laws of this country seriously. And we know that the framers took great care to ensure that the laws of this nation would apply to everyone, regardless of political position. Why? As Mr. Raskin said, we didn't want to have a monarchy. But former Congressman and White House Chief of Staff Mark Meadows has shamefully refused to comply with a duly authorized subpoena issued by your committee, and he has done this without even claiming that some of the things he doesn't want to testify to are privileged, because we know they are not. And the bottom line is this: we're a nation of laws. We're not a nation of kings and vassals, as Mr. Raskin has said. Every citizen in this country has got to recognize that the law applies equally to them. It is our duty here to make sure that happens and do that on the House floor. And so for the sake of our democracy, I urge my colleagues to support the rule, the underlying resolution, and I yield back.
Thank you. Mr. Neguse. All right, Mr. Neguse.
Sorry, my apologies, Mr. Chairman. I just, again, would echo the sentiments of my colleagues on my side of the aisle. I certainly think that they have said it well, and express my gratitude to Vice Chair Cheney and to Chairman Thompson for their collective leadership. This has clearly been a contentious process, and one that has required, I think, poise and decisiveness, and ultimately, above all else, a commitment to getting to the truth about what happened on January 6th and exposing those facts to the American public. And so I want to say thank you to both of you. You have done a tremendous job, and I think the way in which you've worked with each other in ensuring that the committee's business is achieved is something for everyone in our country to follow and to emulate. So with that, I yield back.
Thank you. I just want to make a couple minutes of closing remarks, just for the record. I think it's notable that as of the start of the meeting, that there has been zero mentions on Fox News of their host's text to Mark Meadows. The text that Ms. Cheney read last night at the Select Committee's meeting, not one. And that's despite the fact that one of the hosts that texted him was live on the air all morning. I can't account for what was said while we were in this hearing. But look, I'm glad that these hosts privately pushed to stop the violence on that awful day. But what I'm upset about is that is what they've publicly said ever since. That what happened that day somehow wasn't the fault of Donald Trump and his allies. That what happened really wasn't a big deal. That all this is being overhyped. This would be a good time for these hosts to use their platforms to tell the American people the truth, just like they were privately texting Mark Meadows the truth on that terrible day. That the president's inaction hurt us all, that he should have done more, that he should have pushed to stop the violence. But I have to say that their silence is deafening. And I just also want to remind my colleagues what one lawmaker texted to Mark Meadows after the January 6th attack, and let me quote, "Yesterday was a terrible day. We tried everything we could in our objection to the 6 states. I'm sorry that nothing worked," end quote. Now just think about that. A lawmaker is apologizing for failing to steal an election, for failing to overturn the will of the American people. I mean, is that really what our politics have become? You know, destroy democracy if your team isn't victorious. And I'm really worried that some of what we are hearing from the other side is just an attempt to run out the clock, to keep things in the dark so the truth stays buried. So we're here today to get to the truth, and that's what this is all about. And the final thing I'm going to say is I was here on that terrible day on September 11th, and I had my share of disagreements with the Bush-Cheney administration. But on that terrible day, in the aftermath of that horrific attack, Democrats and Republicans came together, stood on the steps of the Capitol, sang God Bless America, and to try to show the citizens of this country that we are one, and to show the world that we're united in our outrage against the terrible violence that we just experienced. And I thought after January 6th, what we all witnessed, what I witnessed, one of the last people off the House floor, I saw these people face to face. I thought when that was all over with, something similar would happen, that we would come together and all speak as one in our condemnation of what happened here, and all be committed to getting the truth. That didn't happen. And the lack of curiosity, the lack of outrage, the rationalizations why we shouldn't be compelling people to testify is just stunning to me. A number of people have said it, and I know you have as well, that, we're at a crossroads. Our democracy is being threatened, and this is serious. And as I said in the beginning, coups very rarely succeed the first go-around, but they oftentimes do the second time around. So this really, if there's ever a moment to kind of be above politics, it's now. And I get it. Maybe if all the primaries were out of the way, and we were having this discussion, maybe it would be a little bit more balanced. But we have an obligation to get this right. And I want to commend the chair and the vice chair for their courage in doing this work. I think history will reflect well on what you were trying to do here, and we want you to succeed. So with that, no other people wanting to ask questions, you are free to go, and thank you so much.
Thank you.
I now want to welcome our next panel to testify, Representative Armstrong. I see him on the screen, but all right. Can you hear us?
I can.
Okay. The floor is yours.
Thank you, Mr. Chairman. 12 days ago, this committee held a hearing on a related contempt resolution against Jeffrey Clark. Since that hearing, the D.C. Circuit has issued its holding in Trump v. Thompson, which found that the former president's claims of executive privilege are not valid. My Democratic colleagues have proclaimed that this opinion justifies all of their actions and goals. It does not. The committee's repeated attempts to hold individuals in contempt of Congress is not timely and therefore unjustified, while the recipient of the subpoena is exercising his legal right to challenge the subpoena. As I stated in my December 2nd testimony, the application of executive privilege in this scenario is not our decision to make. Our decision is to determine whether this pending contempt referral is premature. By acknowledging the various court proceedings that will ultimately determine the validity of Mr. Meadows' objections, my Democratic colleagues implicitly confirm that these legal challenges to the committee's subpoenas are legitimate. Finding that the legal challenges are valid and knowing that the legal rights are not exhausted, it is illogical to hold in contempt the individual who asserts that legal challenge. President Trump has already announced that he will petition the Supreme Court to grant cert in Trump v. Thompson. In fact, in the ruling issued on December 9th, the court gave President Trump 14 days to file his appeal. We are holding a contempt hearing today, and the deadline for filing the appeal is not until December 23rd. Regardless of any opinion associated with the ruling, and I'm sure there are many, one thing is for certain: the D.C. Circuit is not last. Holding a contempt hearing because you really like the opinion does not toll the timelines created by that same ruling. President Trump's case is still pending. Mr. Meadows' case is still pending. The committee cannot have it both ways. You cannot cheer a substantive legal holding and declare it as dispositive while ignoring that the procedural rights of the litigants are not exhausted. Political timelines do not alter the continued legal right of Mr. Meadows to challenge the subpoena in the court system. Mr. Meadows has cooperated with the committee in good faith while maintaining a legitimate assertion of executive privilege. He has been responsive to the subpoena by providing nearly 7,000 pages of non-privileged emails and documents, along with over 2,000 text messages. He has offered to provide written answers to questions pertaining to executive privilege. He only withdrew his willingness to be deposed after learning that the committee sought his personal communications from Verizon. The committee's rejection of Mr. Meadows' privilege claims are not dispositive. Mr. Meadows, just like Mr. Clark, and just like any other individual, has a legal right to challenge a subpoena. The court system will determine whether Meadows' claims are justified. Until then, this contempt resolution is without merit. Further, as Mr. Meadows' attempt to accommodate the committee's subpoena while maintaining a good faith invocation of privilege does not meet the contempt statute's mens rea element that one will willfully default on responding to a congressional subpoena. Mr. Meadows is not willfully defaulting. Mr. Meadows has asserted the executive privilege claim and has exercised his legal rights to challenge the subpoena. He has complied with the information request pertaining to non-privileged information. We must also acknowledge that as White House Chief of Staff during the time at issue, Mr. Meadows could be party to every conversation involving the president. The conclusion must be that the contempt resolution against Mr. Meadows is still premature. It will continue to be until the Supreme Court disposes of Trump v. Thompson by denying cert or adjudicating the claim, and the claim of executive privileges, as well as others applied to Mr. Meadows' litigation. Mr. Meadows has sued to quash the subpoena, which was recently filed in district court. And again, while much has made and will continue to be made about executive privilege questions and the DC court's ruling, that is not the only issue being raised by Mr. Meadows. Mr. Meadows has the legal right to ask the court to weigh in on these issues. Recipients of subpoenas retain their constitutional rights and various privileges throughout the course of an investigation. That was decided in Trump v. Mazars, quoting, I think it was either Watkins or Quinn, I don't remember. On the basis of the Verizon subpoena alone, Mr. Meadows clearly has a reasonable argument that the committee overstepped. The subpoena was issued on November 22nd, while the parties were negotiating in good faith and without Mr. Meadows' knowledge. Instructed Verizon to produce information associated with Mr. Meadows' personal phone number. It included subscriber names and contact information, authorized users, times of service, account changes, IP addresses, and other metadata for 4 months dating from October 1st through January 31st, 2021. Trump v. Mazars held that to narrow the scope of a possible conflict between the branches, courts should insist on a subpoena no broader than reasonably necessary to support Congress's legislative objective. Requesting 4 months of all calls, text, and cell site analysis for anyone communicating with the president's chief of staff is a lot of things, but I don't think narrow in scope is one of them. Mr. Meadows has every right to contest this, and clearly the appropriate place to do so is in federal court. In fact, Congress itself has recognized that the courts are an appropriate place to resolve these disputes. During the Whitewater investigation, the Senate threatened judicial enforcement of a subpoena against President Clinton. So to conclude, Trump v. Thompson is still pending. The earliest that case can be resolved is December 23rd. Mr. Meadows has a valid suit that raises substantial legal questions that has been properly filed and will be properly heard. The committee seems unwilling to acknowledge the due process considerations of the court system affords while simultaneously cheering on decisions from the very court system's ruling when it favors their political argument. And just finally, I would say this. You cannot in good faith assert just 12 days ago that Justice Clark should have went to court if he wasn't going to comply, and then today assert that Mr. Meadows cannot go to court if he doesn't comply. But that is exactly what's happening. No matter how much many of you want that to be different, the fact is this. The party issuing a subpoena is not the final determiner as to whether that subpoena is valid. And it doesn't matter if it's in Congress or a plaintiff in a divorce case in family court. And while that might screw up political timelines, it also ensures that the process is determined by a third party without any political skin in the game. And with that, I yield back.
Thank you. I have no questions. Mr. Cole.
I just want to thank the gentleman for his testimony, which is very consistent with what he delivered when he was here last week. I think he makes a really superb case, and I commend him for that. But I know we're on a tight timeline, Mr. Chairman, so I'll try to facilitate us getting to the floor as rapidly as we can. I know we all want to do that, so I will yield back.
That's why I love you. Mrs. Torres.
No questions.
Dr. Burgess.
I'm going to assist the ranking member in complying with the tight timeline. I yield back.
Anybody on our side want to say anything?
One thing.
Perlmutter?
I guess not.
Oh, no, you can. Yeah.
Just curious, Mr. Armstrong, Mr. Clark, in his most recent letter, said he's going to assert the Fifth Amendment. Any idea why Mr. Meadows hasn't suggested that?
I have no idea. I can't speculate.
I yield back.
Mr. Reschenthaler. Mr. Raskin.
Just 3 quick points in 60 seconds, and the gentleman can respond if he wants to. Number one, his entire argument was devoted to places where there might be some controversy around privilege, although I don't think that really exists, but fair enough. What about the 9,000 pages where any claim to privilege has clearly been waived and abrogated? Does the gentleman not think that the committee has the right to interview Mr. Meadows about all of these unprivileged documents that he voluntarily submitted to the committee? Number two, as opposed to the theory offered by the chair and the vice chair of the committee that Donald Trump's calling his book fake news was the precipitating factor of Mr. Meadows pulling the plug suddenly on his participation with the committee, you offer the suggestion that it was because he discovered suddenly, I think many weeks later, that his phone records were somehow at issue with the committee, but in fact, the committee's not going to get the substance of any communications. It's simply the records of calls having taken place, and I think the gentleman would agree that the Supreme Court has said that that is not material that's covered by Fifth Amendment privilege or Fourth Amendment, or that requires a subpoena. That's just an objective fact in the world whether calls took place. And finally, I think the gentleman has offered misplaced emphasis on the Mazars case, which deals with a situation where there's a conflict between the branches. Here, the two branches agree. President Biden has said for the executive branch, there's no executive privilege that's being asserted, and Congress agrees that this material is absolutely necessary. And of course, as you know, the D.C. Circuit found that not only was there no compelling interest to override the people's right to get this information, but Donald Trump didn't even offer one. I yield back to you, Madam Chair. Or if you have any comments you'd like
I don't
to
think
make.
it would be. I don't think it'd be a hearing, Mr. Raskin, if you and I had a little back and forth, unless you and I had a little back and forth on something. One, on the negotiation thing, I would say this. Negotiations are either completed or they're not. And I've read all of the correspondence, and I would actually contend that Mr. Meadows has worked very diligently to provide non-privileged information and has at least expressed viable options for dealing with the privilege issue. But you cannot reasonably expect somebody to show up in an adversarial position when you have essentially told them that you will ask them about what is being contended to be privileged in the middle of the non-privileged information. That is an unrealistic place to be. It is an unrealistic place to be in an adversarial deposition. And either negotiations are complete or they're not. And you just say, we're going to ask you about unprivileged information, but then we're going to ask you about information, and you do it line by line in an 8-hour adversarial deposition. With regards to the Verizon case, whether it's Fifth or Fourth Amendment implications, and I think this is something that we should be careful of just wholly regarding whole investigation. This isn't a criminal case, and a criminal prosecution is not a legitimate legislative purpose. And as we keep veering into those areas and mixing the grounds, listen, we are reading out of criminal statutes far too often in defense of this investigation. I have to remember that is specifically determined that a case is not a legislative purpose. And with regards to the privilege claim and conflicts between the two branches, Nick, we've talked about this before, and I'll be brief here, has asserted that former presidents have some right to execute a privilege, and it's the totality of the circumstances. That's where, regardless of how this is going to be determined, the times aren't done in court. They just simply aren't. These cases are not finished yet. And so with that, I yield back.
Okay. I'll just say before yielding back to you, Madam Chair, as Mr. Morelli emphasized, if you agree that a certain category of subject is not privileged and you offer documents about it, that does not absolve you of your obligation to testify about it. People are called to produce documents, papers all the time and then testify about them, and a witness doesn't get to choose between them. I yield back to you.
Ms. Fischbach.
Thank you, Madam Chair. And Mr. Armstrong, you kind of, I think you were just getting into it, but Just to be clear, criminal contempt is not subpoena enforcement, is it?
No.
And if the goal is to enforce the subpoena, what action would the majority, would the committee take to compel the information they seek?
Well, you can go to court. I would not pretend what they would think, but you can go to court to compel the information. But I will say this, once you go down the road of criminal contempt, the likelihood of obtaining any testimony at all is significant.
Well, and Mr. Armstrong, the question remains, as with the other resolutions that we dealt with, what legislative purpose or otherwise are they trying to reach with the subpoenas? And so would this resolution have in regard to the stated goals of the select committee?
Yeah, the legislative purpose question is, and that's what I was talking about, going back and forth and inferring criminal conduct, utilizing criminal statutes. That is not a clear, legitimate legislative purpose. It just simply isn't. It may be a great political purpose, but so I think, listen, I just think we should be a little careful about that in general.
Thank you, Mr. Armstrong, and I yield back, Madam Chair.
Ms. Scanlon.
Thank you, Madam Chair. There've just been a couple references suggesting that somehow it's too rushed to seek contempt at this point, or that there have been insufficient efforts to accommodate Mr. Meadows. I would just refer anyone who's interested in what's actually transpired to the Select Committee's report that was filed with the House yesterday, and pages 12 through 19 detail in excruciating detail the issuance of the subpoena 3 months ago, and all of the back and forth and back and forth. It has not been a couple of letters. It has been intensive, and I think the Select Committee has gone well above and beyond any reasonable accommodation, and this just can't be dragged out forever. So with that, I yield back.
Mr. Morelli.
I would.
Mr. Morelli. Mr. Saunier. Ms. Ross. Mr. Neguse. Does any other member of the committee wish to ask a question? Seeing none, I would like to thank our witness for their testimony. Please leave with our stenographer or submit electronically anything that you would like inserted into the record. You are now excused.
Are there any other members who wish to testify on this resolution? Seeing none, this closes the hearing on the resolution. At this time, the chair will entertain a motion from the distinguished gentleman from Maryland, Mr. Raskin.
Mr. Chairman, I move the committee provide for consideration of the resolution accompanying House Report 117-216 under a closed rule. The rule provides that if House Report 117-216 is called up by direction of the Select Committee to investigate the January 6th attack on the United States Capitol, all points of order against the report shall be waived and it shall be considered as read. The rule provides 1 hour of debate equally divided among and controlled by Representative Thompson of Mississippi, Representative Cheney of Wyoming, and an opponent or their respective designees. The rule waives all points of order against consideration of the resolution accompanying the report. Finally, the rule provides that the resolution accompanying the report shall be considered as read.
You heard the motion from the gentleman from Maryland. Is there any amendment or discussion? Hearing none, the vote now is on the motion from the gentleman. All those in favor say aye. Aye. Opposed, no. Opinion of the chair, the ayes have it. A recorded vote has been requested. Clerk will call the roll.
Mrs. Torres. Aye. Mrs. Torres, aye. Mr. Perlmutter. Aye. Mr. Perlmutter, aye. Mr. Raskin.
Aye.
Mr. Raskin, aye. Ms. Scanlon. Aye. Ms. Scanlon, aye. Mr. Morelli. Aye. Mr. Morelli, aye. Mr. DeSaunier.
Aye.
Mr. DeSaunier, aye. Ms. Ross. Aye. Ms. Ross, aye. Mr. Neguse. Mr. Cole.
No.
Mr. Cole, no. Mr. Burgess. No. Mr. Burgess, no. Mr. Reschendahler. Mr. Reschendahler, no. Mrs. Fishbach. Mrs. Fishbach, no. Mr. Chairman.
Aye.
Mr. Chairman, aye.
Clerk report the total.
8 yeas, 4 nays.
The motion is agreed to. At this time, the chair will entertain a motion from the distinguished gentlewoman from California, Mrs. Torres.
Mr. Chairman, I move the committee grant H.R. 5665, the Combating International Islamophobia Act, a closed rule. The rule provides 1 hour of debate equally divided and controlled by the chair and ranking minority member of the Committee on Foreign Affairs or their designees. The rule waives all points of order against consideration of the bill. The rule provides that an amendment in the nature of a substitute consisting of the text of Rules Committee Print 117-23, modified by the amendment printed in the Rules Committee report, shall be considered as adopted, and the bill as amended shall be considered as read. The rule waives all points of order against provisions in the bill as amended. And finally, the rule provides one motion to recommit.
You heard the motion from the gentlewoman from California. Is there any amendment or discussion? Hearing none, the vote is on the motion from the gentlewoman from California. All those in favor say aye. Aye. All those opposed say no. No. Opinion of the chair, the ayes have it. Yeas and nays have been requested. Clerk will call the roll.
Mrs. Torres. Aye. Mrs. Torres. Aye. Mr. Perlmutter.
Aye.
Mr. Perlmutter. Aye. Mr. Raskin.
Aye.
Mr. Raskin. Aye. Ms. Scanlon. Ms. Scanlon. Aye. Mr. Morelli. Aye. Mr. Morelli. Aye. Mr. DeSaulnier.
Aye.
Mr. DeSaulnier. Aye. Ms. Ross. Aye. Ms. Ross. Aye. Mr. Neguse. Mr. Cole. Mr. Cole. No. Mr. Burgess. No. Mr. Burgess. No. Mr. Reschendahler. No. Mr. Reschendahler. No. Mrs. Fishbach. No. Mrs. Fishbach. No. Mr. Chairman.
Aye.
Mr. Chairman. Aye.
Clerk report the total.
8 yeas, 4 nays.
The ayes have it. The motion is agreed to. I will carry this for the majority. Mr. Raskin will carry the contempt resolution for the majority. Yeah, and on your side.
Ms. Fishbach will carry the contempt resolution. Mr. Reschenthaler will carry the matter we just dealt with.
Okay, and the contempt resolution will be up at 12:15, I'm told. 12, I'm sorry, 12 sharp.
12:15, you guys show up at 12.
I just,
Yeah, the Denver's first.
just want to note for the record, we facilitated
You
this
did,
draft.
and I appreciate it. Yeah, so we're still waiting to figure out on the debt ceiling when the Senate's going to be done, but.
Good luck with that.
Yeah, so it could be today, but if it is late into the night, I would prefer that we meet in the morning and do it tomorrow, but we will keep you apprised of what's going on over the Senate. All right, with that, the committee stands adjourned.